morning. I'm an associate dean here at the William S. Boyd School of Law at UNLV. It's my pleasure to welcome you here. Welcome you to Las Vegas. Las Vegas, of course, is well known for its world-class zoo. We hope you have the opportunity to enjoy that. Of course, there's much more to Las Vegas. We have a world-class performing arts center, a $500 million facility called the Smith Center, which we're really excited about. This is the center of the triathlete universe, which gives you some sense of our outdoor possibilities, recreational, leisure activities. It's a wonderful place to live. I'm constantly learning more about Las Vegas. I've only been here a year and a half myself, but the most recent thing that I'm learning about is all the petroglyphs that are on the rocks in the desert canyon, just 5-6 miles from this very spot is a place called the Sistine Chapel of Native American rock art in a place called Sloan Canyon. So there's so much to enjoy here. We hope that you find something that intrigues and interests you and take advantage of what we offer. Of course, what we're offering for you today and tomorrow is this conference that we're very excited about. We thank Jean Sternlight for organizing this. Jean, of course, is one of the leaders on our faculty here. We have a strong scholarly culture. Every Monday at lunch, we have a scholarly talk. We also have scholarly talk on other days of the week, but there's absolutely always one here on Monday. So this semester, we've already had Orly Lobel, Sean Farhang is here on Monday. We have Jim Vander coming up. I point this out to you for a couple of reasons. One, to brag, because that's the privilege of hosting. But secondly, to point it out, in case you're here for a Las Vegas weekend, you are invited to those Monday lunches, and some tax advisors will tell you that would make your trip tax deductible. To our conference on those Mondays at lunch. So this semester, we also have coming up Jeff Stone and Robin Efron are here on the same day, actually, giving 2 different scholarly talks. Which is a sign of our intense scholarly commitment and my profound scheduling mishap. We brag about you to them, so when we have these weekly talks, or more than weekly talks, we brag about this conference, and so that's why I'm bragging about them to you, because this is something that we're very proud of, to have this conference, to have more than 100 people here, to have it organized by Jean Sternlight, who has sort of identified this as a field, a possible field. I understand that's one of the things that we'll have the opportunity to think about what it is these 2 days. It's great that it's interdisciplinary, which is obvious not only from the titles, but from the fact that there are co-authored papers. God forbid we would have some co-authored papers. How wonderful to see that happening with so many of the talks at a legal conference like this one. So it's my pleasure to welcome you here. I do hope that you have a great visit. We're excited about it. We're proud to host this. We're proud to call Jean Sternlight a member of our faculty, and we hope you have a good time. So without further ado, I'll introduce Jean Sternlight.
I'm not as tall as Tom. I'm going to stand here. I don't know if you can see me over the laptop, though. I hope you can. It is such an incredible pleasure to have all of you here because I'm so excited about this conference, and it wouldn't be possible but for the fact that all of you were willing to come. It was about 30 years ago, actually, that I first had the idea that psychology had some relevance to lawyering. I was, at the time, just starting out as a lawyer and realizing that although I learned a lot in law school, I hadn't learned a lot of the things that I really needed to know, and had an instinct that psychologists knew a lot of the things that I needed to know, but unfortunately I didn't know any psychology, so I had to figure out something as I went along. And I had that idea in the back of my head for quite a long time, that wouldn't it be nice if in law school or later we could teach law students and lawyers more about psychology that could actually be helpful to them. And I kept that idea in my mind for quite a while and did nothing with it until I had the very good fortune when I was teaching at the University of Missouri to teach with Jennifer Robinol, who many of you know. She's a law professor. She's also a PhD in psychology. And I had the good sense to ask her if she would work with me on a project to try to introduce more lawyers to some of the information that one can get from psychology. We wrote an article, then we wrote a book, and then I said, gee, let's have a conference. But you know, the point of the conference is I wasn't, and Jennifer wasn't, the only one who had this instinct. There were so many people in so many different disciplines and sub-disciplines. People in law had this instinct, people in psychology had this instinct, people in various aspects of law. So we had in law schools people in the legal writing community, people in the clinical community, people teaching doctrinal courses, people teaching all kinds of things, who independently figured out that various aspects of psychology can be helpful, not just to understanding law, but to understanding lawyering. And similarly in fields of psychology, people have, in fields of psychology involving cognitive or social psychology, have thought, well, this could be useful to lawyering, but then clinicians have very different aspects of psychology that they think can be relevant, developmental psychologists, and now we've got neuroscience. So the point of this conference, which I really think is the first ever, is to try to bring together all of these different disciplines. And we had a real challenge when we issued the call for papers. At first, of course, we weren't sure what would result. We'll issue a call for papers, and who will even reply? Maybe nobody even wants to talk about this, maybe nobody wants to attend. And we were really overwhelmed with the response. We had so many papers, proposed papers, that we had to turn down many good papers. And I had to even turn down some of my friends, which was frankly kind of embarrassing. But what we tried to do in the selection was not just to take the best papers, but really to try to get a range of papers to really try to show all of these different disciplines. So we've made a real conscious effort not to only take, from one type of psychology or one field of law and so on and so forth. And I think it's made for, we'll find out, a really interesting program. I want to give many, many thanks, and I want to also tell you folks about some logistics. I have my notes here to remember all the logistical things. So sometimes this conference is going to be in this room. This is what we call TAM. But sometimes we're going to be just across the way in a nice law school auditorium. And the reason we're flipping back and forth is partly to keep ourselves awake and partly to give ourselves a chance to do setup in the different venues. But I think you'll be able to figure it out. If it says TAM, that's here. If it says Thomas and Mack Newport, it's just right across the way. We've got lots of breaks, partly to entice you to go back and forth between the different venues, because the breaks are going to be good and have things like cookies. Some of the presenters have chosen to put their PowerPoints or their papers on our website. So if you want to access those either during the conference or afterwards, look at the website. I'm anticipating that maybe some people will add things as well as the conference goes on or after the conference. You do have the ability to connect to the internet while you're here. We have a network. If you just turn on your phone or whatever you have, just sign on to the guest network for UNLV and you can get internet connection. When the reception comes this evening, you're going to need drink tickets, but you have those. If you look at your name tag, you've got 2 little drink tickets stuffed into your thing, so don't give away your card. You'll need that later on. If you want to get somewhere and you can't walk there, and you don't want to wait for the buses to take you back to the hotel, you can call for a taxi. In the registration material, we gave you information on how to call for a taxi. There's restrooms back that way. You can ask somebody. There's water fountains. We've tried to anticipate anything and everything. But the person who has done the very most for this conference is Sandra Rodriguez. Many of you have met her. She's the woman standing back there. This absolutely wouldn't have been possible without her. She has covered everything from parking to food to copies to PowerPoints. But if you still need something we haven't provided, she's the one who probably has the answers. So we thank her now, and we'll thank her even more later on. A lot of other people I want to thank. I had, of course, many people within UNLV that helped me. and are continuing to help with things like the computer and the rooms and the catering and so on. My colleagues, of course, have been incredibly supportive and helped with the initial idea. But I also had outside help. I want to especially identify my co-author, Jen Robinall. I called on her, she kind of couldn't say no, but also Donna Shishkowski from UC Davis and Rebecca Hollander-Blumoff from WashU. They were my outside planning committee who helped with paper selection, and that was a lot of work and helped not only with picking papers but organizing papers, so I want to thank them especially. We also got some financial assistance, not only, of course, from our own law school, but University of Illinois' program on law, behavior, and social science was very generous. They're feeding us to all of our lunches during the program. UC Davis School of Law is paying for the wonderful reception that we're going to have this evening. Also, a couple of publishers. Thomson Reuters is paying for some breakfasts and coffee breaks. LexisNexis is helping us with a coffee break. So I'm really, really grateful to all of our sponsors and to all of our helpers, and especially to all of you, and also to the Nevada Law Journal. The Nevada Law Journal is going to publish papers that come out of this. We haven't yet figured out exactly the logistics. If you're a presenter, they will contact you afterwards and ask if you want to present your paper for potential publication. They will do a lot of work on that, and to say just a few words from the Nevada Law Journal, we have Erica Nanini, who's the brand new symposium editor for the Nevada Law Journal. So Erica, why don't you come up here? While Erica's coming up here, if the first panelists would start to move down to take their seats, that would be wonderful. Thank you.
Good morning, everybody. Professor Sternlight said, my name is Erica. I am the symposium editor for Volume 15 of the Nevada Law Journal. On behalf of the journal, I would like to say welcome, and we are very excited to be able to publish a number of the articles that will come from this symposium in our spring 2015 issue 2. We're a relatively young journal, but our staff's hard work has been reflected in our rankings, and we will contact you after the conference regarding logistics. However, as a guideline, our articles are between 20 and 40 pages, 12-point font, Times New Roman. Thank you all so much. We're very excited to be here, and I'm excited to hear your ideas as well. And please feel free to contact me or come talk to me if you have any questions. Thank you very much.
With no further ado, we're going to move into the first panel, and I am the moderator for the first panel. So what I'm going to do is first tell you how much I've enjoyed being able to be the moderator for the first panel. I got to assign myself to that task because I particularly liked both this topic and these presenters. Doug Yarn is someone who I've known for many, many years since I've been in legal academia. He teaches at Georgia State University College of Law. He also helps design conflict management programs. But today, he's going to speak, he's got a very cool title. It is From Lemurs to Lawyers, the Role of Evolution in the Psychology of Lawyering. So Doug, take it away, and I'll introduce the other presenters when we get to them.
I just have this for the alliteration. You're going to love this presentation, which makes me ask the question, if you know what I'm doing to you, is it, well, yeah. How many of you have formal training in psychology? I will sit down. So, I trained at the Dr. Joyce Brothers School, actually, I was an aspiring primatologist, and this is a film which I'll play on this actually, of some of my first field research when I was 12 years old, some 48 years ago. Anyway, I still think there's a paper in there. I was studying why chimpanzees smoke. And so I think Fur on Fire, a Neo-Freudian musing on smoking among pan troglodytes. That probably worked. So anyway, as a primatologist, originally, I guess you'd group me with behavioralists. And I've just shifted to another primate, and that's Homo sapiens. So law is about influencing Homo sapien behavior. And we've relied on various behavioral models over time. And of course, one of the most abysmal is the rational actor model. And we know that doesn't work. We know that people aren't particularly rational. They make suboptimal decisions. This panel is about lawyer decision making. Lawyers make suboptimal decisions as well. We reflect biases, preferences, heuristics, and such. Cognitive errors is what we're calling them because of their suboptimality. So we're here together, I think, trying to build a better behavioral model for what we do. So where do we look for that? Well, the first place I think we go is we go to the brain. Brain equals behavior, and we've learned a lot about the brain in the last decade or so, but these revelations only tell us what is going on in the brain, how the brain reacts to particular stimuli and directs behavior and decision making. This is proximate cause in the science sense. And although this is useful, I think the more interesting question to us should be, why does the brain do what it does? And for a cut at that question, let me cut to the chase. The Earth is over 4 billion years old. Life is at least 3.5 billion years old. It started once with a replicating molecule from which all life descends. Evolution is a scientific fact. Individuals have different traits. Natural selection favors physical and behavioral traits that improve fitness, that's the ability to survive and reproduce. This leads to a prevalence of such traits in the population over time. The brain is not a tabula rasa. The species' typical human brain is an evolved organ that triggers behaviors that improved our fitness in the environment of evolutionary adaptation, the EEA. Much of our behavior is simply hardwired. So, what are the forces that have shaped our brains and therefore our behavior as a species? Let's go back, way back, when the last universal common ancestor started replicating. By replicating, it created the primordial conflict that underlies all human conflict today. Copies competed for the increasingly scarce basic building blocks of replication. And this would have led to a tragedy of the common primordial soup. But the continuation of life happened because mutation led to cooperation among copies of replicating molecules. It led to more fitness among that group of cooperating, replicating molecules. This resulted in a new, more complex multimolecular entity, which is known among biologists as the hypercycle, which in turn competed with copies of itself, providing the conditions, again, for the emergence of more complex entities, such as, eventually, protocells, prokaryotic simple cells, such as bacteria. Bacteria cooperated with each other to eventually form another evolutionary level of complexity, which is eukaryotic cells, simple single-cell animals such as amoeba, which in turn cooperated and specialized to form multicellular organisms, which in turn specialized and cooperated to form societies. Societies of interdependent, cooperating biological organisms. But there's a problem with societies. Living together has its benefits, but it puts us in more direct competition or conflict with each other. So I call this the potluck problem. What do you do about guests who don't bring a dish but eat the food? They gain the fruits of cooperation without the cost, therefore they're getting a fitness advantage over the rest. This would result in non-cooperators thriving over cooperators, eventually dominating the population and collapsing the viability of the more complex organism. Potlucks don't work when no one brings food anymore. So every transition in evolution to higher levels of complexity requires some kind of conflict management mechanism to control cheating and conflict among the lower level cooperators. And the stability of each of these complex entities requires the emergence of these behaviors that discourage cheating among the lower level cooperators and reestablish cooperation. I'll demonstrate this, but we have a computational lab. Feel 50-50 up there. This computer's not doing it, so. All right. So can we have do a repeat play on this? Let's stop it at the beginning. We can get just a very beginning shot of this one. I'll back up just a bit. There we go. Okay. So this is a torus. This is a three-dimensional figure. It's like a donut that we've cut out and put on a flat space so we can demonstrate it. But there are 10,000 agents on here. Each one has been given randomly different kinds of strategy to deal with each other. So there are defectors, cooperators, reciprocators. There's all sorts of different kinds of strategies at work here. After a few rounds, they put each other in a neighborhood, and after a few rounds, they look around at each other and they pick the strategy that got the most points in this neighborhood. So that's the adaptive part of the game. There's a lot more to it, but the darker colors are the defectors and non-cooperators. So I guess I can play it from here. Okay, but you're going to have to switch it back. So watch what happens. Play. The dark takes over. But eventually, cooperators find each other and will dominate the population over time. Otherwise, the population is simply collapse. So you need some system for this to happen. And we know this, can you get me back to my slides here? We know this from Robert Axelrod in terms of the strategy that works as tit for tat. So, tit for tat is the strategy. In our layout, we've actually sort of changed that. The more optimal strategy is a tit for tat with random forgiveness. This isn't working now. There we go. So we find this actually throughout nature, even slime mold. When you brushed your teeth this morning, they all went running for the hills to survive. And one of the things that they did is they formed these little pods, and some of them die, and the ones in the middle live. In order to stay in a cooperative population and survive, they actually engage in tit for tat with each other. In the genes, and there are lots of people that work on this particular thing right now, whatever, working with us. But for humans, it's in the brain. And we call this our reconciliatory cycle. That it's sort of matching emotions and behavior with tit for tat. That's trust and cooperation, a taste for fairness, a justice judgment function, and a vengefulness when we find cheating. But in order to go back to cooperation, the ability to forgive and reconcile, reestablish trust, and continue to cooperate. So if we run this through from a, let me see where I am in my notes. So if we take some of these sort of proximate evidence that's come up around this from, say, the brain paparazzi in neurochemistry, we can show this. This is your brain on trust. This is your brain making a fairness judgment. This is your brain on retribution. The retribution is reinforced by the release of the hormone cortisol to pursue retribution, even at the cost of one's own fitness, which is something called altruistic punishment. It may be a partial explanation for why clients will pursue a lawsuit at a cost exceeding any plausible return. This is your brain on forgiving, and these are two brains establishing trust and cooperation at the same time. If we look at other social primate species, we can see the patterns of behavior. So capuchins, one of my colleagues, Sarah Brosnan, works on this. Capuchins make fairness judgments, as well as pan troglodytes. Lemurs act on feelings of retribution. Chimps will retaliate against alphas at great risk to themselves. That's a female with a baby attacking an alpha. I won't go into the reason. Lemurs make up In fact, forgiveness and the reestablishment of trust and cooperation is promoted by a number of conciliatory behaviors in primates, the most notable of which is kissing, mouth contact, and grooming. The effect of these behaviors is to produce oxytocin, which in turn creates feelings of well-being, trust, and bonding. And there have been experiments with humans as well as giving them doses of oxytocin and seeing their trust levels jump up in economic games. So reciprocal behaviors work well in the environment of evolutionary adaptation, a family-based social, kind of closed, more closed social structure, mostly small bands, closely related individuals. Cooperators can easily be identified. Cooperators can easily identify cheaters. Cheaters have few options. Either they fall in line or they are ostracized, which would be fatal. But what happens when the groups get bigger? So you have this social architecture here, like this, of kind of everybody kind of tied. How do you get from there to here? When you can no longer affect the behavior directly in the same way. When you have a social architecture, this is sort of a scale-free social architecture and networks that are part of our life today. How do you get there? In that place, cheaters can prosper quite well unless you come up with something to deal with it. In fact, in one model of game theory on this, and I'm not going to play this one, but we model game theory on these different social architectures. Much harder to get to a cooperative state, a stable state with these architectures. So the physical evolution just doesn't happen that fast. And basically we're left with Paleolithic brains and behavior in an infinitely more complex social environment. This is referred to as time-shifted reality, and this disconnect explains many of the biases, cognitive errors, heuristics that make our behavior, which may have been rational in the EEA, much less rational in the modern world. So as these complex social architectures emerge, the fitness of these societies increasingly depends on an extension of the biological through the cultural, and that's where cultural evolution comes into play. The creation of social institutions that can effectively manage conflict among the lower level social units, ultimately human beings that compose the more complex social unit. Language, gossip, reputation, expression of norms, morality, ethics, religion, and law, legal institutions, and lawyers are products lawyers are products of cultural evolution for the management of intra-group conflict. So what does this all mean? Well, the psychology of law and lawyering rests on 3.5 billion years of evolution. Law and us as lawyers, I think, need to be sensitive to the behavioral mechanisms that are built into our brains. How is it useful? Well, it sheds some light on the origins of many of the human factors that interest this group, and I think it's plausibly a foundation for a behavioral model to better understand our clients and ourselves and the decision-making that we make. As a behavioral model, well, it's a little incomplete. I've only showed you the low road piece. Nature's not destiny. Individuals are shaped by many factors. And we have a very well evolved executive function, the high road, and we can make choices. There's a bit of metacognition at play. If you know what it is, if you know what I'm trying to do to you, it's not as effective. The better you can manage it. If legal mechanisms rely on rationality, the great challenge in legal counseling is to help the executive function kick in, prevail over the seemingly irrational caveman within. There are also some interesting ethical questions that arise. For example, if people are predisposed to respond favorably to apologetic behavior, do we use this knowledge to manipulate them, for example? Moreover, should we discount the ongoing social utility of the seemingly irrational? There continues to be perhaps a social good still in the preference to punish at risk to oneself. I think there's something really awesome about all this. At one level, we're cogs in a marvelously evolved 4 billion-year-old machine. Mere vehicles for a replicating molecule. But we can have an existential crisis about all that, or we can embrace the fact that we as lawyers can be conscious of our role in the emergence of adaptive cultural mechanisms designed to sustain the cooperation necessary in an ever-changing, increasingly complex, interconnected world. And as humans, we can simply enjoy the random gift of pro-sociality.
What we're going to do is, rather than take question and answer after each presenter, we're going to do it all at the end. So our next presenter on this subject of lawyer decision-making is Randy Kaiser. I think many of you know either him or his work. He does do academic work. He's taught, he's written some great things, some great books and articles. But unlike some of us in the room, he's not just an academic, he's a consultant. He's the principal analyst at a company called Decision Set in Palo Alto that does business consulting with regard to lawyers. So I know we're going to learn a great deal from him. He's going to discuss lawyers, the relationship between lawyers and emotion, which he'll discuss is a pretty tricky one.
Thank you, Gene. Gene has officially allocated 10 seconds for us to travel from Doug's Savannah to our nation's courtroom. So we'll have to be very nimble, and I will be proceeding as rapidly as I can. This paper explains the importance of psychology in attorneys' case evaluations and their client counseling. I'd like to explain why we wrote the paper, what the research told us, and how our colleagues in medical education are dealing with similar challenges. We wrote this paper because of our earlier research demonstrating that attorneys and clients have great difficulty in predicting case outcomes and making economically rational decisions about whether to settle matters or to proceed to trial. We've looked at about 6,000 cases in New York and California over a 40-year period. No matter what state you're looking at, no matter what period you're looking at, generally plaintiffs get a worse result at trial than they could have obtained simply by saying yes to the other side's settlement offer. That rate ranges from about 55% to 63% decision error over a 40-year period. Defendants make a decision error, that is, get a worse result at trial than they could have obtained simply by saying yes to the other side's settlement proposal in about 1 out of every 4 cases. So far, defendants look pretty astute. But when we look at the actual cost of those errors, the difference between what they end up with at trial and what they could have obtained, we see that for those 1 out of every 4 defendants, the results are catastrophic. The average cost of error for defendants is about $1.4 million compared to plaintiffs' average cost of error of $73,000. These results are consistent with Judge Posner's survey of federal and state court judges when he asked them the question, why do cases go to trial instead of being settled? The judges told him that 66% of cases go to trial because at least one side has an unrealistic assessment of the merits. This is completely contrary to the conventional wisdom that cases go to trial because the merits are so closely balanced that they're too close to call. So this was the background for our inquiry. What is wrong with attorneys' case evaluation? We thought we'd go out in the field and find and interview well-calibrated attorneys. We looked at about 3,500 cases in our data sets for cases tried to verdict between 2002 and 2007. To be interviewed, we imposed a dual criteria. Their client had to have gotten a better result at trial than they would have obtained through settlement, but perhaps most importantly, their own client settlement position had to be within 20% of the ultimate award. Now let's keep in mind, could be 20% above, could be 20% below. So it's a fairly broad band. Surprisingly, with a fairly loose criteria, only 8% of the plaintiff cases in California even met this criteria. About 20% of the defendant's cases in California met that criteria. We created a random sample of 200 cases that met this criteria, and 78 attorneys agreed to be interviewed. These interviews lasted about 72 minutes on average. A fundamental question in these structured interviews was, what is the problem with attorneys' case evaluation? Why do so many cases proceed to trial and result in adverse outcomes for the clients? And specifically, we asked them, are these legal errors mistakes about the law, or is there something else that's missing in the attorney's evaluation? And 201, these attorneys told us, you know, the attorneys on the other side are actually pretty good attorneys, but they don't know people. They don't understand people. They can't even determine threshold issues of credibility. They don't know what motivates jurors, and they really don't understand what is a winning case. We got expressions like, the other attorneys live in a bubble. Some attorneys are socially aphasia. 3 times we heard this term, emotionally tone deaf. As one attorney said, I'm not sure whether they will ever hear the music. This was consistent with malpractice claims data that tells us that only 11% of all claims are related to a failure to know the law and apply the law. Somewhat surprisingly, 6% of all claims are due to procrastination. The Canadian malpractice data tells us that most claims are due to client relationship and client communication problems. This is consistent with Chris Guthrie's characterization of lawyers' emotional unintelligence and their exclusive concentration on matters of law, interpretations, and the failure to truly understand the emotional and psychological components of cases. I think I've explained why we did this research and very briefly what we found. We were curious, are there other fields that are grappling with similar issues? And we were quite pleased to see that the medical profession is literally decades ahead of the legal profession in starting to ascertain law school or medical school applicants' understanding of psychology and their development of emotional intelligence. I'd like to highlight 4 trends in medical education that illustrate the breadth of innovation, but also may be applicable in some manner to law schools. First, somewhat shockingly, in 2015, the MCAT will have a 95-minute section assessing applicants' understanding of psychology. This occurs because the medical profession recognizes, as should the legal profession, that the quality of our legal advice is almost immaterial if we don't know how to motivate people to follow that advice. These questions in the new MCAT will assess not attorneys' emotional intelligence, but their understanding of very fundamental concepts in psychology, like the effect of gender, status, and culture on patient compliance with physician instructions. Look at the number of very gooey subjects that are going to be included on the new MCAT. The LSAT, of course, has nothing that even comes close to beginning to assess effects on clients like memory, attitude, culture, personality, motivation, and of all things, mood. Secondly, the medical profession recognizes that they're getting too many applicants who look good on paper but do not perform effectively in a clinical setting. And to prevent this, they are conducting multiple mini interviews. In these, students are given 2 minutes to look at a written description of, quite frequently, an ethical dilemma, and then to meet with an interviewer for 5 to 8 minutes to discuss how they would deal with that ethical dilemma. The key here is that the student is not expected to have the right answer, but the interviewer is probing for the thought process and the ability to communicate, relate, and to be open-minded in the discussion. Third, medical schools are actually engaged in assessing emotional intelligence. And that's because quite a few years ago, the medical profession decided that interpersonal and communication skills would actually be acknowledged as one of the 6 core competencies of a physician. And in our field, I cannot think of any reason why we would give less attention to interpersonal and communication skills, and yet they are not formally recognized in any of our pre-admission testing, and by and large, they are not acknowledged or adequately recognized in our training of law students. One exercise that I find to be particularly effective is ongoing training in empathy. And one technique they use, which is somewhat similar to that used in negotiation classes, is that the students observe a physician-patient interaction. But what makes this different is that both the patient and the physician are wired so that we can graph their galvanic skin response and get some sense for when that patient is stressed, when the resident is stressed, but perhaps most importantly, to test whether our perception of stressful moments is correct. Because we can observe what we believe to be a stressful interaction, but we don't necessarily know what moments, what elements, what factors generated that stress. So when we have the video along with the galvanic skin response graph, we get a brilliantly vivid picture of how to improve interactions with patients. Lastly, in more than 25 medical schools, students actually have to go to a museum. They are required to attend a museum in groups of 4 and to observe a painting. And the first thing they're told is, don't pay attention to the label. And I think that in our practice of law, one of the most important things we can learn is don't pay attention to the label by case type, by type of client. It's so important to think anew and afresh. The students record for 15 minutes their observations, and then they compare notes. And it's remarkable to find out how little some students observe, but when they can compare notes with other students, they also recognize that we invariably concentrate as individuals on certain components of a painting, and it's wonderfully educational to find out that other people literally don't see things the way we do. And this is a wonderfully unintimidating atmosphere in which to learn that. They're told to describe this for someone who will never see it. And when you imagine what we're doing in courtrooms and in talking with clients, one of our greatest challenges is to describe something for somebody who will never see it. They're also asked to develop a narrative. What is going on in this painting? Why is this envelope on the floor? What was the letter in that envelope? Why is that newspaper crumpled there? And in writing a narrative, they end up revealing a tremendous amount about their own biases and how they see the world. This exercise has resulted in a 14% increase in diagnostic skills in medical schools. We started off saying we will explain why this research was done, what the research revealed, and how our colleagues in the medical profession are dealing with similar problems. I hope we've accomplished that goal, and thank you very much for the invitation.
As Randy mentioned, I'm trying to be very, very strict on time, and as you heard from my intro, we had a great number of great presentations submitted, and wish we could have taken them all. We took probably more than we could, so everybody only gets 15 minutes, and we've got to be mean about it. So our next presenters are Doug Frenkel and Jim Stark, who will be talking about whether mediation training actually helps law students, much in the way that Randy described, whether mediation training can help law students learn some psychological skills. Many of you in the room are psychologists or know about psychology, so you won't be shocked to hear that guess what? These guys do mediation training. Maybe it's coincidental. But Jim Stark is at University of Connecticut. He runs the mediation training program there. Doug Frenkel runs the mediation training program at University of Pennsylvania. But they have both also run other training programs in the clinical area. They've written a critically interesting paper. Gentlemen, take it away.
We're going to sit here because we need to communicate with each other. Arden's paper is about numeracy in law students. My numeracy skills aren't so good, but I know that 15 divided by 2 is 7.5, which is pretty daunting. We have the paper posted to the website, so we can only skate the surface of this here. We hope that you will look at the paper, read the paper, and give us your comments, especially critical comments. This paper began as a kind of valedictory essay on why teach mediation. We decided we wanted to write an essay about this as we come toward the end of our careers. We've been doing this for a long time. Doug and I taught advocacy skills to students for many years as clinical law teachers. We each made the transition to mediation training, and we've been doing that ever since, and we thought we would write an essay on why. Doug said to me, well, we could write an essay, but nobody will read it, and only those people who believe in it will agree with you, and why bother? If we're going to do something, it's got to be research-based. So it's his fault, this paper. We decided to focus on the distance and dispassion and neutrality of the mediator's role, which is what is really distinctive about training students for mediation. And relatively early on in the process of looking at this literature, Doug remembered that he went to a conference where some guy named Randy Kaiser spoke. The paper that Randy just described to you, the study that he put up on his PowerPoint, is the study that Doug heard about. We had a conference version of that paper, and then we got the final published version of that paper. And that paper serendipitously provides the frame for our paper. And I say it's serendipitous because I don't think there's any way that Jean could have known the relationship because she didn't have our final paper at the point she made, this panel decision. But one thing that Randy did not say about his study is that in terms of calibration and quality of prediction, one of the findings of the study was that lawyers who had background in mediation, who listed themselves as members of one or another mediation group or court panel, were much better calibrated in their case predictions than lawyers who weren't. And the results are quite striking in some subcategories of cases. And we try to think about, why might that be true? And that led us to the huge, vast literature on cognitive and motivational biases. And we began to look at some of the cognitive and motivational biases that it's been shown affect either negotiators or people in the business of making predictions about future outcomes. Studies that really are strongly associated with what lawyers do. And then we began to look at the smaller but still quite considerable literature on de-biasing. And so we found evidence for the strength, in particular, of two de-biasing interventions. Interventions that reduce the kind of cognitive and motivational biases that Randy described and that lawyers are very prone to. One is called perspective taking. This is something I'm sure all of you have heard about. And the other is called consider the opposite. Trying to force people to articulate and maybe list or write down reasons why their confident predictions about the future, why their judgments, why their beliefs might be wrong. We think that both of these de-biasing interventions are very strongly related to what effective mediators do. And we think that, in fact, the ability to do these things in mediation is often the hallmark of good mediation outcomes.
So let me take just a few minutes to give you a sampling of the research that we did in one of these areas, perspective taking. If you're interested in reading further, obviously you can look at the paper. First, and with apologies to the mental health people in the room, let me just define how the research more recently has differentiated perspective taking from empathy, because these terms tend to be conflated, at least in the law school literature. Perspective taking is defined as a cognitive or thinking process, mentalizing as it's sometimes known, the ability or the tendency to imagine, consider, and understand, perhaps even momentarily adopt how another person is seeing a situation. Not necessarily the way you are, but how they are seeing the world at that moment. By contrast, empathy is, at least currently in the field, defined as an emotional response, connecting with someone at the heart, through the heart rather than the head, and feeling what they are feeling in that moment. They are related but very distinct processes. Perspective taking. Let me just give you summaries of some of the areas that we think are particularly applicable to the work, first of all, of lawyers. This was our main frame. And one big strand of research in this area is in the world of so-called stereotyping, especially outgroup stereotyping, the kind of heuristic or distorted way of seeing people that leads to all kinds of inaccurate attributions to them. And a classic study that typifies this is a scenario in which subjects, of course undergraduates usually, who are paid $3 an hour, but subjects are shown a photograph of an elderly man sitting in a chair near a newspaper stand. Classic stereotype invitation, and they and three groups are asked to react to this. One is asked to think about what this man's life is and to write an essay about a day in his life. Another group is told to suppress any stereotype thoughts you may have in that, and the third control group is given no instruction. And those who are given active perspective-taking instructions, the essay writers, in studies like this one, and this one in particular, it turns out, produce less conscious and unconscious stereotyping about the elderly, about an outgroup. Other studies in this area show that perspective takers tend to like the members of groups that would otherwise be stereotyped more than if they didn't do this, and want to help those in those groups. All things that might be relevant, I think, and helpful to lawyering. There is a downside here, perhaps, or at least a conflict in the results. The way this tends to work, it turns out, is that we see the other person, we see ourselves in the other person by virtue of doing this, that this can produce sort of some ironic consequences. Those who were told to take the perspective of a college professor, it turns out, did better on an SAT-type test than those who were asked to take the perspectives of a cheerleader. Maybe not surprisingly. Another big area of bias relevant to lawyers is the so-called egotistic bias, the area that leads us to have distorted views about what we think is fair in terms of our tactics, our claims, our clients' positions, and so forth. And to give you a sense of how this has been studied, it turns out that when a group of 4 subjects does a task jointly and is asked to allocate his or her own share of responsibility to the group effort, the cumulative totals for individual scores is approximately 160% of the total effort, a logical impossibility. When first asked to take the perspective, to consider what other people's contributions were, and then do the identical task, the cumulative total is approximately 106%, closer to what you would mathematically expect. There is, however, a cynicism that can set in even in this form of perspective taking, and that some of the research tends to show that when the process can also involve projections or predictions that the other person will act aggressively and almost in a defensive format can lead the perspective taker to act more rather than less aggressively. Similar research has, perhaps unsurprisingly, shown that perspective taking can lead to distinct advantages of overcoming the so-called disadvantages of anchoring bias or the vulnerability to being anchored in a negotiation, or to being hampered by the so-called fixed pie bias that can get in the way of integrative or value-creating solutions in a negotiation. Let me just say one other sentence and turn it back to Jim to conclude. This activity is not only at the heart of what mediators do. It is a form of discrepant or oppositional or difference mindset that is at the heart of what mediators do when they are listening, when they are interpreting, and when they are, if they're successful, persuading. And it's our contention that we hope, if the literature bears this out, that this is distinct enough from the rest of legal training to make it transferable from one domain to another.
The empirical literature in support of the efficacy of consider the opposite prompts is quite strong, and it has been shown to be effective in a wide variety of different kinds of domains. The domain of social theories, for example. Do you believe in capital punishment or do you not believe in capital punishment and its efficacy? The domain of predictions about future events, like am I going to get employed and how many job offers am I going to get? And most relevant for our purposes in things that are related to disputing and legal disputing. So just to give you one example of a study that was done, actually it's 2 studies that were done over a period of several years. George Lowenstein and Barbara Babcock and their associates did 2 studies of law students and undergraduate students and then later MBA students, in which they took a kind of complex, nuanced motorcycle accident that was based on a real case that had been tried to a judge in the past year or 2. In which the claim was made for $100,000. The judge decided the case and awarded, I think, $34,000. They were given identical case file materials. They were assigned to be either the plaintiff's representative or the defendant's representative. And in the first study, because of confirmation bias, the tendency to approach information from a confirmatory point of view, you're assigned to a side, and you tend to view the evidence through that side's lens. This is a cognitive bias that kicks in. Even though we know that we should be open-minded about information, we can't be. We tend to adopt a confirmatory approach towards information. They found in this first study that students assigned to the plaintiff's role, on average, evaluated the case as being worth $14,000 or more than the defense side. In the second study, they replicated the study. They used a control group, this time with MBA students. But they also gave a subset of students a consider the opposite kind of prompt. The prompt read, disputants don't always think carefully about the weaknesses in their own cases and therefore are surprised when the judge's ruling is worse than their expectations. Therefore, please think carefully about the weaknesses in your case. In the space below, please list the weaknesses in your own case. And they found that that prompt was highly effective in reducing overconfident predictions and in reducing the amount of impasse in a subsequent simulated negotiation that students engaged with. In the control group, without that instruction, 35% of the students reached impasse, and they were like $20,000 apart on their prediction about the case result. In the group that received the consider the opposite instruction, there was only a 4% rate of impasse, and the students were like $5,000 apart. So why does this relate to the work of mediators? This is what mediators do. By dint of their role, they are listening to one party after another. They are developing a kind of bipolar or multipolar attitude towards the information that they're receiving, and they're helping each side consider the fact that their overconfident predictions may not turn out the way they expect.
Wonderful. Thank you so much. And Doug, not only on their brilliance, but on their numeracy and keeping within time. And as they say, we now have Arden Rowell, who's going to present the paper that she co-authored with Jessica Brigand, who couldn't be here. Jessica is actually a PhD student at University of Chicago in behavioral science. Arden, who's here today, is a law professor at the University of Illinois. With no further ado, can you figure out the technology? Yes, brilliant.
Great, thanks so much, Jean. So I'm also going to be talking about legal decision making, and in my case, I'm going to be talking about the relationship between legal decision making and numeracy, or math skill. So basically, there are a bunch of behavioral findings about the relationship between math skill and decision making for health and financial decisions. My co-author and I wanted to know how those findings would generalize to decision makers with legal training who were thinking about legal problems. And it turned out that, at least as far as we could find, there just wasn't any empirical data out there on attorney numeracy. So there was lots of anecdotal evidence, there were lots of bad jokes about how bad attorneys are at math, and there were a couple of good jokes about that, but there's no real data. So we decided to run just a short survey, and we ran it on about 150 Illinois law students, using them as proxies for the attorneys and judges that they'll become. And I'm going to be talking about the results of that study today. All right, so the rest of the structure of my talk is I'm going to give you a little bit of background, a very little bit of background about existing literatures, non-legal literatures on numeracy and decision making. Then I'm going to talk about a few different puzzles about legal decisions in numeracy that we're hoping that the survey will help inform. And then if there's time, I'll wrap up with some thoughts about extensions and potential challenges. So first, just a little bit of background about existing numeracy research. Basically, research in finance and medicine shows that people with low numeracy, people who are relatively poor in math, they make different decisions about money and about health, and they also appear to be more susceptible to bias. So, as far as the substantive decisions go, people who are less good at math tend to be sicker, they tend to be poorer, they're more likely to be unemployed, they're more likely to die young, they tend to experience greater anxiety about a number of different kinds of risks. You give them the same information and they'll be more worried about many different kinds of risks. That's one set of findings. The second set of findings has to do with susceptibility to bias. So here, the literature shows that people who are bad at math, worse at math I should say, are more affected by framing effects, they're more affected by particularly loss aversion, whether the choice is presented as a loss game. So reading this literature, I thought create some concerns when we start to think about what this would mean if these findings also apply in legal context to legal decision makers, to lawyers. So here are three questions that we generated out of that literature. And so the first question just has to do with baseline levels of math skill. And so what is the scope of this problem? Are lawyers really bad at math? Again, I assume all of you have heard jokes about this, and certainly have experienced it in my own teaching, that when I do bring up math, or I have numerical examples, or I put a simple graph up on the overhead, students get very anxious, they often complain about it. You're all familiar with this trope that lawyers are bad at math. But are they really? Second, does being bad at math affect legal decisions, affect the substance of legal decisions? This would be potentially worrisome on a bunch of different fronts. And third, we wanted to see if this literature from the health and financial contexts applied to lawyers in regards to the susceptibility to biases. So if lawyers are bad at math, and if people who are bad at math are more susceptible to bias, does that mean that the lawyers who are bad at math are more susceptible to bias? Again, potentially worrisome. So I'll talk about each of these and hopefully at least start to inform each of these questions. The first question. Just how bad are these law students at math? All right, so here's the kind of question that we ask the students in order to answer this general question. So we have a sweepstakes, the chance of winning a car is 1 in 1,000, and we ask them what percent of tickets to the sweepstakes win a car. They gotta fill it in, there's a blank, there's a percentage, they have to manage the percentage, make sure they get the decimal point in the right spot. That's super easy. It's easy to mess up and move the decimal point one too many spots. Here's the answer, 0.1%. All right, and we're going to get these questions just straight from the financial and medical decision-making literature that's already done work on numeracy. All right, so here are the three questions that we asked. These are the classic three questions that are most used in the health and financial context to measure numeracy, excuse me. And here I'm going to show you is how the public does on these questions. So what we care about, at least for current purposes, is what's going to happen in just a minute. I'm going to show you how law students did on these questions in comparison. So are the little bars going to be higher than the bars that are up there? Are they going to be lower? That's what we want to know. Okay, so here's the result. Every single question, the students did much, much better than the general public. A lot better. Here's another way to show the same data. So this is just showing a general population. If you give people a numeracy score, how many of these three math questions did they get right? This is the distribution that you get. General population. Law students, big difference. So if you want to talk about means, the public has a mean numeracy score of 1.36, and law students have a mean numeracy score of 2.4. A significant difference. Very significant. All right, so how bad are these law students at math? Not bad. Not bad at all. At least compared to the general public. Now, does that mean that attorneys are good enough at math? Maybe that's maybe something we could talk more about. But at least compared to the general public, they're much better. Or better than students are. All right, that second question we wanted to talk about has to do with substantive legal decision making. So, do the legal decisions that are made as attorneys counsel their clients, as judges make decisions, do those vary with the numeracy of the decision maker? So here we have a question. It's just a classic kind of learned hand setup. And so we tell the students that they're representing a client. The client failed to take a $1,000 precaution that had some chance of preventing $5,000 in damages, and that the damage occurred. So based on that information, how likely was it that the court would find their client negligent? So this is helpful or not, but this is just showing that if all I tell you is the student's numeracy score, I don't even tell you which condition they were in, they were randomly assigned conditions, then we can predict a significant amount of the variance in how likely they are to tell their client that they were negligent, just on the basis of how they did all these 3 DAF questions. Here's another way to look at it. So here's the different conditions broken down. So some of them were told there's a 1% chance of the precaution preventing the harm, some 5, some 10, some 20. Here I've broken it up between students that scored relatively poorly on the numeracy test. And I say relatively poorly because really they did so well that there's a statistical power problem. We didn't have a lot of really, really low numeracy people. So these are people who got 2 or fewer answers correct on the test. So this is their results. Here's the results for students with high numeracy. Right, so the difference between these are statistically significant in the 1, 5, and 10% conditions. Here's maybe a third way to think about this. What we find is that when students are asked to predict how likely it is that their client will be found negligent, in conditions where their client likely is negligent, at least doctrinally according to the hand formula, the inefficient precaution conditions of 1, 5, and 10%, we see a significant difference between what lower numeracy and high numeracy students would counsel their clients. So, do legal decisions vary with do substantive legal decisions vary with the math skill of the decision maker? Yes, at least sometimes. Right. Final question has to do with susceptibility to cognitive bias, that we're just hearing about. So here what we wanted to know is, since there's this research showing that in medical and financial contexts, people with lower numeracy are more susceptible to bias, should we have the same kind of concerns for our students and for attorneys who have low numeracy? So here, this is a very long question, sorry. So basically the idea is this is drawn straight from existing numeracy research. The basic point of this question is whether people's perception of risk varies based on whether information is presented as a percentage or as a proportion. And past research has found that this framing effect disproportionately affects people with low numeracy. They're very much affected by whether they're told about things as percentages or as proportions. So we're going to see here if that same thing happened for law students. And it doesn't. So it's just a failure to replicate, but it's going to be still an interesting point as we continue to think about how it is that we'll generalize from non-legal behavioral research into legal behavioral research. There's another study on susceptibility to bias, and here we're measuring 2 different things. We're measuring loss aversion, and we're measuring how likely it is that students will counsel settlement. So basically, for this question, we asked students to consider, in a particular case, whether they should tell or encourage their client to settle, or whether they should encourage them to go to trial. This ties directly, perhaps, into what Randy was just talking about. So we told them that after researching, they determined that for clients like theirs, either 3 out of 4 cases like this one are successful at trial, or 1 out of 4 cases like this one are unsuccessful at trial. It's the same odds. It's just, are you thinking about the success, or are you thinking about the failure? Often the same settlement, and then based on that information, how likely are they to counsel their clients to settle? What we find here, what we find is that first, everybody is showing significant signs of loss aversion. Right? There shouldn't This is the same information, just presented two different ways. One is a loss claim and one is a gain claim. So really, the chance that you would counsel your client to settle should be the same between these two different sections, right? But it turns out that while there is a significant difference between a loss and a gain claim, which is replicated research that's already been done on loss aversion, and showing that it also applies here to law students with this kind of question, there's not a significant difference in susceptibility to loss aversion on the basis of numeracy. It's maybe encouraging to suggest that lawyers are less susceptible here, at least on this numeracy front. All right, so are low numerate decision makers more susceptible to bias? No, and I should say this is not low numerate legal decision makers. And it means this is to say that they're not more susceptible, at least when they have some legal training and when they're making some kind of legal decision. All right, so these are the three questions that we asked at the beginning. Whether lawyers are bad at math? Well, at least with using law students as proxies, not as bad, at least as your full wisdom would have us think. Does being bad at math affect legal decisions? Well, it appears to be predictive of at least some kinds of substantive decision making. And are lawyers who are bad at math more subject to cognitive bias? Well, lawyers are subject to cognitive bias, but they don't appear to be more subject to it based on their numeracy. So maybe just a couple of quick reflections about what all this might mean. I guess the first reflection I've already alluded to, which is I think that it's important to all of us as we're thinking about particularly transferring non-legal behavioral research to legal realms, to really question when we're doing that, whether we're following the right kinds of parameters. If there's something special about law, whether it's because it's a mechanism for cooperation, or because of something that it does in our brains that encourages us to think in a different way, it could be that some kinds of behavioral research is difficult to transfer once you put it into the legal realm. Generalizability of findings, I think that the main thing to point out, which I'm sure you all do this anyway, is of course this is run on law students, so it's very possible that there could be differences between law students and the general lawyer population. How big would that difference be? If anything, it could be the case that, so there are other numeracy research that suggests that as people get older, and particularly as they reach retirement age, their numeracy skills start to decline. So it could be that particularly older members of the legal profession may have lower numeracy on average than law students. And this could be important as opposed to, particularly if you're looking at judicial numeracy. And third, and this is maybe what I think is the most interesting kind of question, when thinking about accuracy in legal predictions, I just want to add a caveat here. So what our research shows is that different numeracy on the part of a legal decision maker can lead them to different substantive predictions. But what we don't know from this study is who's right. So are low numeracy law students who are predicting that taking an inefficient precaution is relatively likely for their clients to be liable for negligence, are they the ones who have it right? Or the ones who follow essentially the Hannon formula and give us doctrinally what we teach our students? Are they the ones who are getting it right? Could be that students with a higher numeracy tend to have a lower emotional intelligence. Right? So we don't know yet from this study which of these groups tends to be more accurate in their legal predictions. It's something to be for future research. And then finally, I think there are potentially additional implications for thinking about legal education, how we ought to be educating attorneys, and also for research.
Thanks to our numerate presenters and our great timekeeper, who I should introduce, Lydia Nussbaum. We now have some time for question and answer. And Lydia, if I could ask you to bear the microphone. For what we're going to do is, before I throw it open to the audience, and I will do that very soon because we've got a lot of brilliant minds in the audience, but before I did that, I wanted to see if any members of the panel wanted to address either questions or very brief comments to one another. Not to expand upon your own work necessarily, but to ask questions or comments. Anna? All right, well then I'm going to throw it open to the audience. If you do have a question, please raise your hand and Lydia Nussbaum will bring you the microphone as quickly as possible.
Thank you very much. I have a question about the numeracy of law students, which I find fascinating. You compare their numeracy to the general public, and I'm wondering how they compare to other professional students, so medical school and business school, because you often hear law students say they went to law school instead of some other professional school because they're not good at math. So was there a comparison there? How does it shape up?
Yeah, great question. So we wondered this as well. So we have a follow-up study where we are generating our own population, the general population, and measuring their numeracy. And what we found preliminarily is actually that the law students are significantly more numerate than your average person with a bachelor's degree. And that they actually hold their own with their average person with some graduate education. Now, how does that work when you sort out people with graduate education in accounting as opposed to in English? We don't have yet the granularity on that to be able to say. I think we can make some pretty strong predictions about that. But at least what we find is that they do hold their own in general against even people with some graduate education.
Hi, Jeff Stemple from UNLV. Kind of two questions, or 1A and 1B on numeracy versus some of the other things we've talked about today. And I apologize for not knowing the literature better. I'm always struck by how low dollar these thought experiments are with the undergraduates. You know, $10,000, $1,000. Has anybody done much with 50, $500,000, $1 million, the sort of things that corporate lawyers, at least in big time plaintiffs' attorneys, will look at? And then I'm curious as to whether there's some subconscious fusion of some of the other things we're talking about going on. So for example, if I'm counseling a client at $5,000 versus $10,000, and I'm working on a 40% contingency fee, I empathetically will want to think about, does my client want to go to trial, how much aggravation, how high the spike of their blood pressure, does it interfere with vacation plans? And I'm trying to figure out if anybody has attempted to control with that, and I guess my trial hypothesis would be, if it's $1 million case, you say, suck it up, kid. We're going to trial if these numbers don't work out. If it's a $10,000 case, you have all sorts of good reasons for being innumerate when you advise a client about a case.
I'm going to try to take a stab at this. This is a long-winded answer to part of your question. I think that there is a dissonance, a tension between Arden's paper and Randy's paper, in that Arden's paper takes a view, at least in the negligence problem, that courts make decisions based on economic rationality, using something like the hand test in making that decision. Whereas if you read Randy's paper and his conversations with well-calibrated lawyers, the theme is entirely the opposite of that. That's not the way jurors and courts decide cases. They decide cases based on emotional factors, the empathy of the client, whether they like the person who's seeking damages for his injury and so forth, whether they're credible or not. So I would think that, to come back to the question, I would think that at least a personal injury case with a $1 million injury would be reacted differently by a jury than one with a $5,000 injury, and the jury would be much more likely to feel compassion for the person suffering the injury, and even if instructed about the burden of precautions in the hand test, which I don't think most courts do instruct juries that way. But even if they were instructed that way, I think the jury would just throw that out and decide the case based on their empathy for the injured plaintiff.
So I guess I should clarify, I'm not actually in this project suggesting anything about what courts actually do, whether they follow the hand formula or don't. What our research shows is that attorneys appear to think differently about negligence based on how good they are at math. And so I actually think that I'm not sure that there is a tension here between our work and Randy's. Randy's is showing that different attorneys tend to work differently under certain kinds of circumstances. If he's trying to inform the question of what the problem is with many attorneys' case evaluations, part of the answer to that could be numeracy. So it could be that since attorneys vary in their numeracy level, that part of the difference in their predictions has to do with that numeracy, especially given that now we know that sometimes that does affect their substantive decisions.
The answer to your question about how big dollar scenarios affect attorney's judgment, I recommend that you look at Jeff Raklinski's paper entitled How Lawyers' Intuitions Prolong Litigation. He uses larger scale scenarios.
And what does he find if there's a big difference?
He finds, well, he doesn't compare small scale scenarios with large scale scenarios, but he does look at what you're deeming to be the realistic type of scenarios and finds that the biases are troublingly persistent.
I have a question for Andy. And here I think there is potentially a disconnect or a tension between your paper and our paper.
You're such a troublemaker.
And this has to do with the tension between passion and dispassion. And the question is, what combination of passion and dispassion potentially produces the best judgment by lawyers? I was interested, our paper focuses on teaching dispassion, teaching objectivity, and posits that mediation training and practice is a good way to do that. But your conversations with well-calibrated lawyers seem to focus more on the passion side of things. Being really zealous and empathic for one's own client. And so I wonder what your thoughts are about that.
I tried to include some of the quotes in the paper to demonstrate the remarkable ability these attorneys have to know when they were becoming, as they saw it, too emotional. For them, it was almost a minute-by-minute awareness of how emotions could strengthen their advocacy and how the emotions could damage their advocacy. So I think what really distinguished these well-calibrated attorneys is this constant process of backing off, being able to take a perspective on themselves, and this, to me, exceptional degree of self-awareness and self-regulation, which is so indicative of expert performance.
We've got the question in the back.
Hi, I'm Corey Rosenfelder from the University of Colorado. I have another question about numeracy. So I have two questions, really. One is the numeracy issue a question of degree? So, for example, I have a friend who's a theoretical physicist. Will he be, if he were to receive legal training, would he then be vastly superior in his predictive abilities as compared to your average accountant? And would that person then be vastly superior as compared to our students who majored in English and went on to law schools? That's one question. And my next question, which is related, is to what degree is numeracy, of the kind that's been studied in the literature and the kind that's represented in your study, could it be a proxy for educational experience of another kind? So, put another way, are students who receive higher quality education in their primary and secondary educational experiences, those with more privilege and better access, do they perform better on these kinds of questions than not average people, but than students who are less advantaged, or are these questions really able to get at something that transcends experience?
Okay, so briefly on the second question about the relationship between education and math skill, there is a relationship between education and math skill, and there's also a relationship between math skill and gender. There's also a relationship between math skill and race. But even when you take all of those things out, there's still something separate. It's a separate variable that operates separate from any of these other factors. So essentially, the best study that I know of that tries to take account of education level, race, and gender finds that those account for, on total, about a fifth of the variance in the general population on numeracy, with all three of those things together. So numeracy still varies a lot, even with the same level of education. Second, your first question, is it's about degree. I think it is about degree, and I guess where I would actually go with this, though, is to say 3% of our law students got 0 of these questions correct. And that's potentially very worrisome. And we might worry there, particularly, if we're going to talk about accuracy, we might worry particularly about that group of people. Not because their predictions are more or less accurate, which you still don't know that, but because they may just be making numerical errors in calculating damages. They may just be adding, subtracting, multiplying, and dividing incorrectly. And so I think that's a separate kind of accuracy concern, but one that we might have particularly for this low end of the spectrum.
And I know there are many more people with questions, but in an effort to stay on schedule, we're going to end this session. However, there will be plenty more opportunities for question and answer informally. We're heading next to a coffee break. It's in the building right over there, the next building over. It's got coffee, I think probably cookies, good stuff, restrooms. So what you do, if you had additional questions, and I know there were a number of you, just nab the people that you have questions of and ask them, and now let's give a hand to all of them.